We had some new filings today. This time they're pretty easy to consider. Thankfully, these documents are all limited to page number, and that helps a lot. One more is expected by midnight Eastern Time, and it's about 15 minutes away, so I'm going to try to add that one at the end if I can. This first one is a follow-up to Wayfair's motion in opposition to Jonesworks' motion for a protective order. And let's all say the word hypocrisy together. They mention the response was filed a mere 2 hours after because they want to frame this a certain way. If you recall, we covered this motion for protective order a couple of episodes ago when Jonesworks wanted to claim that the communication between themselves and Edgeworth Securities was work product. Work product is material prepared for trial. It's hard to define and easy to abuse because it covers things that are in the attorney's minds. And like I said, if someone claims it, it's hard to say that it's not because you can't prove it's not in their mind. Unless, of course, it's too far-fetched. It covers things like mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. I feel like in this case it really is a stretch. This security team is the one that took Jennifer Abel's phone contents and ran 2 scans of her personal laptop. With the role that they played and the causes of action being brought against them for those actions, they're going to have to do more than just supply communication. They're most likely going to have to testify, I would guess. I could see communications since the lawsuit was filed. Yes, they reasonably could be speaking about legal strategy, but the communications during that time, there was no lawsuit. So it really is a stretch that those will qualify as work product. But back to their claims here, they're saying that Wayfair never mentioned a crime fraud exception, that their privilege claim is well-founded, and that they were hiding their intent to use this exception in order to ambush them. The footnote even describing it as lying in wait. They use the term sandbagging. I think of sandbagging as when a lawyer stays quiet during a trial when they notice a mistake, and they hope to use that as a reason to appeal the case later, which isn't usually successful because if they wait, they waive their right. But maybe they're just using it as the attorneys were keeping quiet. Calling it litigation by ambush is a little dramatic too, because that usually means concealing information or evidence from one side in a legal proceeding until the trial or hearing, leaving them unprepared to adequately respond or defend. Now, this tactic can disadvantage the opposing party by denying them sufficient time and opportunity to investigate and prepare a robust defense. But this isn't anywhere near trial. This is discovery. And again, the hypocrisy is astounding. They're literally talking about the actual ambush that they did to Jennifer Abel and claiming that they're now being ambushed by this exception. But is it really even an ambush? He's been talking about this ambush of Jennifer Abel for a long time. He's been asking for the subpoena related to the sham lawsuit for a long time. He added new causes of action to the complaint that are listed as federal and state crimes. That's been a couple of weeks now. None of this should be a surprise to anyone. This was always going to come before the court. Ever since he found out about it, this was going to be an issue before the court. He just needed the proper chance to introduce it. They should have been ready for this. And so in this request, she promises the court what her response is going to hold if the court allows her to make it. She says that 1, the facts stated in the Wayfair party's response are flatly false, and she wants to show that. She wants to show that their counsel knew that they were false. 2, that their invocation of the crime fraud exception is patently frivolous because they failed to present even 1 iota of evidence to substantiate their false assertions, despite acknowledging that they must do just that to support application of the exception. And 3, the Wayfair parties are abusing this court's docket for extrajudicial purposes, including to launder defamatory statements about Jonesworks through documents ostensibly protected by the litigation privilege. Can you believe this? This woman, who stands accused of committing actual crimes for her part in the sham lawsuit, is talking about abusing the court. This sham lawsuit does need to be dealt with now that it's been discovered. And Wayfair only found out about this sham lawsuit because it was discovered by outside people. Daily Mail had been shown the subpoena. Without a crystal ball, found the lawsuit. If these 2 things hadn't happened, Wayfair still wouldn't know about this because, as they said in their last filing, they still haven't received a copy of that subpoena. It would have taken seeing that subpoena to have found what lawsuit it was linked to. They're just mad that their little scheme was uncovered. Now let's just answer why this letter was filed instead of just filing the document. Document 206 is in order, and it's Judge Lyman's response to this request. He says, okay, but you've got to have it in by midnight tonight. This is not really common for it to be demanded on the same day, which is something that makes me think he's not too pleased about the recent chain of events. It could be that, or it could just be that federal judges' schedules are really tight, so they do tend to be very strict about keeping things on time. But still, an extra day or two wouldn't have disrupted the schedule, really. So I do tend to lean a little bit more towards he's just had it. Now the next line, he says no further submissions on this motion absent leave of court, which is why she asked permission or leave to file this document. So documents have limits for how many can be filed without the court's permission. This keeps the docket from being overwhelmed. Once you reach that limit, anything else you want to file after that, you have to ask the court's permission. So, like she had to for this document, it applies to things like amended complaints as well. It also applies to the number of people that you can depose. That number is usually 10. Beyond that, you can do, but you need to ask the court's permission, and you have to provide the court with the reason why you need to exceed your limit. I don't know how it's been decided in this case, because there are so many plaintiffs and so many defendants, and each plaintiff is a defendant, and each defendant is a plaintiff. So, I'm not sure how that all worked out for this specific case, but there are a lot of rules like this, and when I see one, I'd like to bring it to your attention. This next document is from Wayfair, and it's in opposition to the motion to compel that was filed by Blake that we considered just a couple of episodes ago. And as always, with Team Wayfair, the writing does not disappoint. It starts off by bringing up the contradiction in the filing, and that is, they say that she simultaneously acknowledges that the Wayfair parties have confirmed that they will produce non-privileged documents concerning their damages, but also, B, incorrectly argues that the Wayfair parties have refused to produce specific financial records relevant to their damages. So you see the contradiction. They acknowledge that they said that they will produce, and then they say that they've refused to produce. And I love how the Wayfair team picks apart those little things. They also say that Lively's true purpose in filing the motion was not to compel discovery, but to fabricate a headline for the media. And they both keep accusing each other of playing this out in the media, and I think both sides, to be fair, are playing this out for the media. But he turns it right around on them by saying Blake herself hasn't produced a single document, or explained how she searched for and collected the documents that her counsel claims to have gathered from her, but, as he says, not produced to us. Both sides are shouting, give us our discovery, while simultaneously not producing the discovery that they've been asked to give. And next we move on to the conversations that they had in their meet and confer. Now remember, the meet and confer is what they have to do first. They have to try to resolve these things amongst themselves. And if that doesn't work out, then they come to the court. So he says that during that meet and confer, that the Wayfair parties assured Blake that they were in the process of gathering documents to respond to her requests, specifically that they would produce non-privileged documents concerning their respective damages. Remember, that was a big thing that they addressed in their motion to compel. They needed proof of these damages that Wayfair has claimed. And he repeats, the Wayfarers did not refuse, but that they suggested that when they provided the damage-related documents to Blake, that if Blake felt that additional documents should be produced, they should notify the Wayfair parties of that position, and then they could meet and confer in good faith in connection to that. So not only did they promise to provide, but they also had a path that if they didn't provide well enough, what they could do. They say that Lively agreed to this, and that she hasn't explained why the procedure is insufficient, and mentioned the fact that there are already so many motions on the court's docket. So basically saying, hey judge, they're wasting your time with this, and we don't know why because we thought we had this all worked out. And I can't help but think when I read these remind me of when you and your sibling are in trouble, and your parents are trying to get to the bottom of what happened, and you're each trying to save yourself, so you're pointing fingers at each other. And that's what this feels like to me. They both get on there and say, well, Judge, I thought we had this figured out. I don't know why they said this to you. And then we find out what the objection is. It turns out Blake is asking for too much yet again. This time, it's everyone's net worth. And it includes a lot. They're asking for financial statements, assets, liabilities, and tax returns. And they say that their motion fails to explain why the net worth of each of the Wayfair parties is relevant to any party's claim or defense and proportional to the needs of the case. And that does seem like a stretch. Why does their net worth matter? This is about business loss. Why do you need their personal net worths? It just feels like Blake's team always crosses that line. They mentioned tax returns. And tax returns do contain private and sensitive information. It includes things like your dependents. It can include certain health conditions of yourself and your dependents. And of course, it just has information well beyond the scope of what these claims are. They cite some cases here that show that courts have long been reluctant to order discovery of tax returns because of this sensitive information. And these cases have established that if you want tax returns in civil cases, that there's a two-part showing requirement. 1, the returns must be relevant to the subject matter of the action, and 2, a compelling need must exist because the information is not readily obtainable from a less intrusive source. And they say that Blake has not shown that the tax returns are relevant to the subject matter of the actions, and so her request for such information should be denied. And they have a workaround for that. They didn't just flat out refuse. That if Blake just says what information she needs that's on a tax return, that they can provide that information through a less intrusive source. So whatever it is that she's looking to find from a tax return, that there should be alternative sources that aren't as intrusive as the actual tax return that they could supply instead. This is a reasonable workaround. And of course, they didn't let me down about the cited cases that were used by Blake in their motion to compel. As always, they looked them up. And as always, they found they didn't fit yet again. It's just amazing to me that Team Blake hasn't yet learned that the Wayfarer Council looks up every citation every time. So they really need to stop embarrassing themselves by these erroneous citations. But the first one, they say that the phrase tax returns isn't even mentioned in this case. So they don't know why she cited it. The next one does contain it, but the background of it was that the court directed the plaintiff to produce his tax returns after he failed to produce other documents, such as financial statements concerning his alleged damages. But they say, in this case, we're going to produce documents concerning the damages, so you don't need it. In the last case, the tax returns were relevant because a judgment had already been made and they needed to enforce that judgment. There was debt owed, and this person the judgment was against had not been cooperative in producing any of the financial documents required, so they had no other choice but to compel the tax returns. But as they say in this case, there hasn't been any judgment, much less in Blake's favor, so that case doesn't apply. Now, in addition to the overreach for tax returns, they say that there's still more of an overreach beyond that, because they're seeking for all documents concerning your liquidation of assets in 2024 or 2025 for any reason related to the film or the actions including but not limited to the sale of shares in any publicly traded company. But they say that nowhere in the letter does Blake even attempt to explain, let alone sufficiently explain, how any such documents are relevant to her claim. He says that even during the meet and confer, that a basis for this wasn't provided. And then, no document of theirs would be complete without the spicy wit. It says in her self-serving and lengthy summary, in quotations, alluding to the fact that it was so lengthy it could hardly be called a summary, and memorialization of the parties meet and confer, Lively does not explain why documents concerning any liquidation of assets is relevant to any claim or defense herein. And then he cites a case where a motion to compel like Blake's was denied because they didn't say how it was relevant. And he sums it up by saying that she failed to meet and confer about her request for documents concerning the liquidation of assets, and that this violates Rule 4C of Judge Lyman's individual practices, and then omitted from her motion to compel any justification for the production of such documents. And this one is submitted by Kevin Fritz. I love how in harmony these guys are. You really can't tell when you're reading the document which one it comes from. Their writing style is all very similar. They are really on the same page. Next, we have what I call a housekeeping document. And when I say that, what I mean is it's more on the administrative level. It has to do with organization. And this is a normal document for when discovery finally ever starts coming in. We've been in discovery for quite some time, and it sounds like nobody has turned anything in. But in cases like this, there's going to be a lot of information. There's going to be all the information that's been subpoenaed. There's going to be transcripts from depositions. It's all going to come together and form an evidence pile. In this case, we don't just have two sides. We have multiple plaintiffs and defendants. And since there are counterclaims, like I said earlier, every plaintiff is also a defendant and every defendant is also a plaintiff. So that's going to be a lot of stuff. They're going to need a way to organize it. In addition to that, it's hard enough when it's two sides, but we have multiple sets of counsel. So this requires one standard for how to organize this mountain of evidence, because they will all have access to it. Ultimately, this will be for trial purposes too, because at trial, both sides will have a list of each other's evidence that they will need to refer to prepare. So they all have to come together and come up with these lists. Things like definitions, so that when they say a specific word, they all know what that word means. They have to set up a search protocol that includes things like file types and sizes, a known location for files that's regularly maintained, instructions for hard copies and electronic copies, how to handle redactions and privileged information. Again, Team Blake really needs a class on that. They really keep messing that up. And finally, something that's called Bates labeling. This is a unified method of labeling files to keep everything organized. It's both for themselves to keep their own things organized, and it's also for use down the line. And ultimately, during the trial, everything that gets introduced will be on this list, will be Bates labeled, so that the other side can follow along and be ready to rebut it. It's really the only way to keep things organized. Now, this table shows how to properly label things for this case, and there are 6 of these tables that cover every type of evidence from documents. Emails have a certain standard, phone messages, electronic files, and that's what this long document is about. Just making sure that all of this stuff is prepped and organized and ready to go. And I just looked, and of course, JonesWorks filed their motion just in time to try to refute Wayfair's claims for this crime fraud exception. And they come in with colorful language as expected, claiming that Wayfair is trying to invade their attorney-client privilege and work product. They also bring up this accusation of litigation by ambush, and they call this exception an outlandish theory, and they say it was never raised during the meet and confers, and that it asserts facts without an evidentiary basis, which is why the case is probably going to need this evidentiary hearing, and also why Justin's team requested the in-camera review, and it is the type of hearing that the Supreme Court has deemed proper as a solution for proving crime fraud claims. And they attempt a little gotcha moment here by saying that Wayfair failed to contest that the documents they seek are privileged, and that by invoking this crime fraud exception, that they're conceding that they are privileged. Now, it's funny that they call this an outlandish theory, because they took things off of Jennifer's phone that they had no legal right to take, and then they subsequently shared it. They also handed over the contents of it to a sham subpoena without notifying their own contracted clients and former employee. And the reason they didn't inform them is because they knew what they were doing wasn't okay. Now, this mention of them acknowledging that these are privileged, if that's in fact true, that could be a risk if the court does not grant them this crime fraud exception. But if the hearing finds there's no crime fraud, it means there's nothing actionable in it anyway, so there would be no reason to seek it. They say that this crime fraud exception fails to meet any of the requirements for the exception, and since this privilege was not otherwise challenged, that the court should uphold it. They go on to state this two-pronged standard for crime fraud. This was also covered in the Wayfair's motion. They are that the client communication or attorney work product in question was itself in furtherance of the crime or fraud. Stephanie used this to continue to access Jennifer Abel's phone until January of this year. She also used it to give this information to Blake before the sham lawsuit and after. I think that's pretty easy to prove. And 2, to believe that the particular communication with counsel or attorney work product was intended in some way to facilitate or to conceal the criminal activity. It did facilitate. It helped Blake get this information that she had no right to, and it concealed the criminal activity that she had gotten things off this phone she had no legal right to get, and shared it. So in order for Blake to use it, they needed to do a sham lawsuit to show why they had access to this information. So these two sound perfect for the situation. They go on to say that it's Wayfair's burden to prove by a preponderance of evidence. And as I said, I think there is in fact evidence that something very unholy happened here. This little stunt that they pulled is so abusive of courts. I would think that any good judge would be angered and offended by their actions. But we're just going to have to see what Judge Lyman thinks of it. Now here is where we step into the land of make-believe, where she seems to think that they have to prove everything absolute in order to get an in-camera review. Her own words contradict that. All that they need to show is sufficient evidence to support a reasonable belief that an in-camera review may yield evidence that the exception applies. Now remember, an in-camera review, we talked about that last time, it's the judge looking at the evidence himself, ex parte, or with only one side, without the opposing counsel, and that's just to protect the sanctity of work product, in case he would find that it is in fact work product. Now she goes on to say that the Wayfarer parties fail to even attempt to connect any of their arguments to any particular privileged document or documents. And here's where she tries to throw it off track. She speaks about documents from May of 2024. Now, I'm not sure what she's referring to. There must be something that they requested from that time period. The important stuff happened in August. So there must be something that they're also requesting from May. And if I've read that before, I don't remember it offhand. But they focus on this because they know how serious the August stuff is. And they go on using words like outrageous, as if that will make it so. I mean, these claims are so well-founded that she has to focus on what she can. For example, she focuses on this false imprisonment because that claim was dropped. But all of this demanding of evidence that she refers to here, it's really just puff. Because all that's required for this exception is a prima facie showing. That's not proof beyond a reasonable doubt. It just needs to be plausible. Another thing you have to prove in order to get this in-camera review is that the communications must be intended to help the client commit, cover up, or otherwise advance the illegal or fraudulent activity. So the fact that she notified Blake's team on the very day that she collected the evidence, and that's what led to the sham lawsuit, the fact that she complied with the sham subpoena, it really shows that she intended harm on Jennifer and Wayfarer. They say there's no evidence, but Jennifer's testimony is a type of evidence of these events. And the judge's in-camera review can verify it. There's no explanation that she has for taking that information to them. And there is evidence, the text that Leslie Sloan sent stating that she'd seen the text and is going to sue. That's evidence. There will be evidence of their communication. How did she get this to Leslie? There will also be evidence of Jennifer's iCloud being accessed. These go a long way to prove plausibility. Then she pretends that this sham lawsuit is nothing. She says that they present only 2 documents, a complaint filed by a third party, and the notice of discontinuation of that litigation. That's what she boils this sham lawsuit down to. Oh, it was just a complaint, and it was just discontinued, completely ignoring the subpoena that was the result of this, and was the whole reason that this lawsuit was filed. And this is the furtherance of a crime, taking this illegally obtained information, finding a fraudulent way to share it in an attempt to make it seem legal. It wasn't legal for Stephanie to have some of the stuff that was on that phone, and it definitely wasn't legal for her to pass it along to Blake. He would have included the subpoena in evidence if he actually had it, but he doesn't. And then she says neither of these documents offer any factual or evidentiary support for any of the Wayfarer party's wild claims. They do not relate to Abel's termination in August. They do not relate to Abel's return of her JonesWorks owned iPhone to the company at the time. Like I said, fairy tale land. How can she say it doesn't relate when the entire sham lawsuit was set up specifically to collect that information? And we find more of her words designed to make it seem like it's not so, but no matter how much you say wild speculation, it doesn't make it wild speculation. The whole series of events is recorded and traceable. Calling it bombastic doesn't help either. And they say again that it falls short. They try to cling again to something that they can say because this false imprisonment was actually dropped. So of course they're going to bring attention to that. But there is evidence that she both accessed and shared personal contents of Jennifer's phone. There's the link of how did Leslie Sloan know about the texts? How did the sham lawsuit come to only serve a subpoena on her, specifically on Jennifer's phone contents? There's no way there was such a narrow scope if they didn't have knowledge of this. There's no way they would have even known that she had access to Jennifer's phone in the first place. How would they have known something like that? They wouldn't have. And then she says, if the Wayfarer parties had evidence supporting any of their inflammatory assertions, they would have presented it to this court. That they did not both confirms the non-existence of evidence and defeats their opposition. What they have is enough plausible foundation to have the in-camera hearing to find the evidence to prove it. The actual evidence is what they're trying to get from her. In her own documents, she talks about this lawful subpoena. So now she needs to supply how and where that subpoena came from, and how Blake knew to ask for this one piece of information. Specifically, Blake didn't ask for anything else. How did she know that information was there? Why didn't she ask for something else? How was this information handed over so quickly? What form was it handed over in? Did Blake get a whole new extraction of the phone, or did she simply take the stuff that Stephanie had already extracted? All of this has to be shown, but the subpoenas have to be allowed first. She's saying you don't have evidence while she's holding the evidence hostage. It makes no sense, but nice try, Jones Works. There's a lot before the court right now, and as impatient as I am, I'm glad that Judge Lyman has taken his time. He must be feeling some really intense pressure right now. Taylor has now filed a motion to quash for the subpoena that was delivered yesterday. Blake and Ryan rushed out to do the same in their last-ditch effort to try to save her, but I think we need to let that develop a little bit first, because there's a lot that's unclear at this point. For example, it seems to be addressed to Taylor's attorneys, so I don't know if this was an additional one that was served on her attorneys, or if the one that was directed to her is this same one that was in her attorney's name. So I think we have to let this develop a little bit before I can tackle it. Till then, this is Cassidy O'Connell saying stay well and stay tuned.